I want to thank folks for attending here tonight. We're going to talk about a really important subject and something rather new here, which is called supported decision making. And our presenter, he's going to introduce herself as Suzanne Francisco. We've done some programs on this before, but this is going to be much more in depth. In fact, it's going to be at least a 2-session program, but maybe 3 here coming up. And this is something that that we're going to see a lot of focus on in the future. Now, I was sharing with Suzanne and Ellen that I teach once a year at the University of Texas, where they already have their supported decision-making statutes up and running. And I know when this first started that there was a lot of concern about whether or not this was practical or not. And a year into it, we're finding that it really has been a great tool. So it's interesting to see what's going on in another state, and we're really excited about this coming to California. Now, for those of you that are listening, we are very interested in answering questions, but what we're going to do is, if you have questions, what we'd like you to do is put them in the question box. Ellen's going to be monitoring the questions. We're probably going to take the majority of them towards the end of the presentation so that we can keep the flow going here. So anyway, without further ado, I want to welcome Suzanne and thank her so much for taking some time and sharing with us. And so maybe you could tell us a little bit about yourself, how you got into doing disability advocacy and some of the advocacy work that you've done. So welcome aboard.
Thank you so much, Stephen. My name is Suzanne Francisco, as he mentioned, and I am a disability rights and special education advocate. And I want to tell you a little bit about how I got here and how this journey all began for me. I grew up with a sister who was very courageous and juvenile diabetic, and later we found out she was bipolar. And basically she was rebelling against what was happening to her, and in that time she did some damage to her body, and she was basically in and out of hospitals for about 31 years. She became blind, she lost a leg, and her organs were shutting down. So she was immensely courageous, and my mother was incredibly loving, and my sister ended up in a group home, which was really inappropriate for her. She was at the end of the last bed of the last hall with people who were not her peers, although I'm sure very lovely, and she was taken away from her community, and she basically was expected to live without dignity and not have a choice. And ironically, she wasn't conserved, and it was still such a challenge for her to get through the systems and to advocate for herself and advocate her way out of that group home. And it was immensely difficult, and you can imagine how that feels for a person. And she ended up volunteering as a mentor speaker after she was able to leave the group home to youth, young people in the hospital just discovering that they had diabetes. And she passed living independently with the supports that she needed. And that journey was very impactful for me. And she taught me a great deal. And later, or actually while she was still with us, I had 3 children, and unbeknownst to us, they had a rare form of congenital muscular dystrophy and autism comorbid, excuse me. And so my children are nonverbal. They use AAC devices. They're very sensory seeking and defensive. They have some behavioral challenges. They have fine and gross motor challenges as well. And so I spent many, many years advocating for my children, and then I decided to hire an advocate one day, and he hired me. So that has begun the second half of my journey here of advocacy. And since then, I've been specializing in assisting and empowering individuals with exceptional needs and their families to navigate systems and get supports and services that can be provided for them through faith, educationally, that's a free, appropriate public education, and or in their communities to preserve their disability rights. And my mission is to advance the lives of people with disabilities and those who are vulnerable so that they are self-expressed and direct their own lives to the maximum of their abilities. And to have the same self-determination that people without disabilities take for granted. So it's my pleasure and my honor to do this work. And how I came to the world of supported decision-making is one day at a conference, I went to a session about supported decision-making. I met Jonathan Martinez, who ran the session and did the keynote in relation to his case that he had won for Jenny Hatch, who is a young lady with Down syndrome, who was able to avoid conservatorship and lives independently now. So since then, I collaborated with the National Resource Center for Supported Decision-Making, the ACLU, and some other agencies in supported decision-making outreach and education, bringing awareness to people in California. And the essence of why I do this is that I believe every human being has the fundamental right to make choices through expression, to learn how to express themselves, and that they can express themselves. Very passionate on that subject, and I am now working with KPS for Parents, which is Knowledge Power Solutions for Parents. It's a nonprofit, and again, I work as a disability advocate and special education advocate. And if you bear with me here, I'm going to get my tools to function. So speaking of expression, how an individual can express themselves and that they can, I want to talk about presumed competence and the lesson that I learned really that gave me an aha with my son is that basically my children had the inability to communicate to some extent. They had pictures to communicate with, and I really felt like I knew my son, I knew what he was capable of, and I would talk to my children and ask questions, but really, you know, I was asking myself the question, not thinking that they could answer my questions. And one day I was sitting on the bed next to my son, and he has been the most challenged one, should I say, and he's always had a really hard time expressing himself and had behavior as a result of that. And so I was sitting on the bed next to him, and I asked a question, and all of a sudden I saw his head shaking yes. And I was, are you answering my question? And so he shook his head yes again. And I thought, no, I seriously didn't think that he knew what I was talking about. And so I asked him in many different ways, and essentially he was absolutely answering my question. I verified that that was true, and I just, it's like trumpets were playing. That was a really big moment for he and for myself to realize how frustrating it was for him, for people to not be able to access his abilities, and for him to be unable to access his abilities and be limited, basically. And I don't really remember what the question was. What I remember is that he was able to answer the question. And so what I would say about that is that I felt that I knew my son implicitly, that I knew what he knew. And really, I didn't. And so now I presume competence until it's proven otherwise. And I just, it was a very powerful moment for me, and part of why I'm doing what I'm doing today. So based on that experience, my own experience, I ask everyone here to be open to possibilities and to be open to new thinking. So I want you to just think about this. We've all done this. What decisions do you make for your child or individual that they could be making for themselves? Think about that. And if you are not a parent, think of someone you know you have made decisions for, or someone else that you know that tends to make decisions for other people. And we all do this. So think about that moment. If you're an individual with a disability, think about what decisions other people make for you every day, choices that you notice people make for you. And for an example, in teaching problem solving, take a toddler, for instance. We can teach decision making and teach each individual to make choices to some extent from a very early age. And it's really about being cognizant of the decisions that we're making for people. So if you're asking yourself, what decisions could my child or my individual be making at age 2 or at age 22? So every parent and supporter makes a million decisions every day that the child or the individual could be making, because it seems easier that way. I'm a parent. I understand. I have 3 children with special needs, and we're moving. And often it seems easier to make those decisions ourselves. But consider, in the long run, that we all really benefit more through the ability to make choices. So, what have we tried first? First, I will say that I will never say that there is never a need for conservatorship or guardianship. We're really talking about a continuation of options and looking at the full continuation includes supported decision making. And I want to just point out that in every other state, I believe in the United States, they call conservatorship guardianship. In California is the only state that refers to it as conservatorship. Other states may use the term conservatorship to mean guardianship over financial issues. In those states, the conservator makes the financial decisions and the guardian makes the other decisions. So again, before you think of conserving your child, which is what most of us are familiar with, professionals, parents, individuals alike, many people aren't aware that there are options other than conservatorship. So the question I encourage you to keep asking is, what have you tried first prior to thinking about conservatorship? So rights equal choice. I am my choices. I cannot choose. I do not choose. This is still a choice. Excuse me, I am going to move something out of the way of my slide so I can see them. I am my choices. If I cannot not choose. If I do not choose, that is still a choice. If faced with the inevitable circumstances, we still choose how we are in those circumstances. Jean-Paul Sartre. Rights equal choice. Choice equals self-determination. Self-determination gives an individual control over their life, people's abilities and opportunity to be causal agents and actors in their lives instead of being acted upon, spoken about by Wayne Meyer. The benefits of self-determination. People with greater self-determination are healthier, they're more independent, more well-adjusted, and better able to recognize and resist abuse. And I want to go back to that for a moment. If you think about being taught to make decisions and being self-determined and problem solving, when you come across a situation, if you have the skills and you've been taught something, you're more likely to know what to do in that situation versus if somebody is making decisions for you all the time, you may not have that skill set. So guardianship in the United States, there are plenary and full guardianships. Guardianships gives the guardian power to make all decisions for that person, used in a vast majority of cases, as long as the law permits plenary guardianship. Courts will prefer to use it. So plenary is a full guardianship. As a result, guardians have substantial and often complete authority over the lives of vulnerable people. This includes the power to make the most basic health, personal, and financial decisions. We've known for 40 years when denied self-determination, people feel helpless, hopeless, and self-critical. They may experience low self-esteem, passivity, and feelings of inadequacy and incompetency, decreasing their ability to function. And if you think about it, when you're feeling self-determined, you feel proud, you feel hopeful, you're in high self-esteem. So it's very important that we encourage people to live self-determined lives. And people with greater self-determination have improved psychological health, including better adjustment to increased care needs. People who exercise greater self-determination have a better quality of life, more independence, and more community integration. And women with intellectual disabilities exercising more self-determination are less likely to be abused. And again, I think in any case, any woman that is learning about self-determination and learning how to make decisions and assessing the situation, people learning those skills are less likely to be abused. People with intellectual and developmental disabilities who do not have a guardian are more likely to have a paid job, live independently, have friends other than staff or family, go on dates and socialize in the community, and practice the religion of their choice. Guardianship may be needed in emergency situations. If the person is incapacitated and cannot give consent, the person did not previously identify how decisions should be made in that situation, there is no one else available in the person's life to provide consent through a power of attorney, advance directive, or other means. To support people, we face critical decisions and have no interest in or ability to make decisions. We need immediate protection from exploitation or abuse. Guardianship is never needed just because you have an IQ of whatever the number is, or just because you're sick, or just because you need help, or just because it's always been that way, or for your own good. Really, the decision about guardianship is one that is unique and individualized to each person and should be the last question we ask rather than the first question that we ask. People under guardianship can experience a significant negative impact on their physical and mental health, longevity, ability to function, and reports of subjective well-being. Alternatively, older adults with more self-determination have improved psychological health, including better adjustment to increased care needs. People with disabilities who exercise greater self-determination have a better quality of life, more independence, and more community integration. So where do we go from here? If we know that some people need more support as they age due to disability, and we know that guardianship can result in decreased quality of life, we know that increased self-determination leads to improved quality of life, then we need a means of increasing self-determination. So a way forward, supported decision-making. Supported decision-making is a recognized alternative to guardianship through which people with disabilities use friends, family members, and professionals to help them understand the situations and choices they face so they can make their own decisions. That is a long definition. And what that means is having a circle of support to help you in those areas that you need assistance. So if a person can make decisions with assistance or support, is she incapacitated? Are you? If you can make decisions with assistance or support, are you incapacitated? So supported decision-making is an alternative to guardianship. Alternatives to guardianship, including supported decision-making, should always be identified and considered whenever possible prior to the commencement of guardianship proceedings. And I want to read that again because that is by the National Guardianship Association. Their opinion, the National Guardianship Association, is that alternatives to guardianship, including supported decision-making, should always be identified and considered whenever possible prior to the commencement of guardianship proceedings. And so really, again, it's about looking at the continuum of options and asking, what can we do first? So if you think about it, how do you make decisions? What do you do if you're not familiar with the issue? Something like taxes or medical care, auto repairs. You go and ask your accountant. You ask your doctor. You ask your mechanic. And you are considered doing a very competent, good job. Whereas often people with disabilities who are asking for help are looked down upon and their inabilities are focused on, whereas when we ask for help, our abilities and our knowledge is acknowledged there. So before we choose guardianship, we ask, what else have you tried? Supported decision-making can help people understand information, issues, and choices, focus attention in decision-making, weigh options, ensure that decisions are based on their own preferences, and interpret or communicate decisions to other parties. I think, as I mentioned in the beginning when I asked you, what decisions do you make for other people? Or what decisions are other people making for you that you could be making? I think often we don't think about it, and there's nothing wrong with that except for that we need to pay attention to it. It's just something that we do. We often don't pay attention to decision-making. And decision-making is a skill that can be built over time and should start with each individual where they are. Supported decision-making is a paradigm, not a process. It's a framework and a way of thinking. So there's no one-size-fits-all method of decision-making. It can be included as appropriately in informal support, written agreements like powers of attorney, identifying the support needed and who will give it, micro boards or circles of support. And really, supported decision-making is a very personal, individual, unique process that should be based upon, again, the person's unique abilities and preferences. Opportunities for supported decision-making. Informed consent for medical care is an example. Person-centered planning, what's important to and for that person in Medicare and Medicaid. Student-led IEPs are often very popular, where the student is at the head of the table and contributing to their own IEP. Informed choice in vocational rehabilitation, and the conversation and 5 wishes for end-of-life planning. So supported decision-making and special education transition services. The whole purpose of IDEA, the Individuals for Disabilities Education Act. The purpose is to ensure that all children with disabilities have available to them a free, appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. And those are key terms there. Prepare them for further education, employment, and independent living. Still, guardianship is the default option for students with intellectual disabilities, and school personnel are the most frequent source of recommendations that parents seek guardianship. And in my particular case, I've been to parent engagement conferences where there are workshops on conservatorship, and really there has been no information available about supported decision making, and often people are not aware of supported decision making, but it is also not, the school is not the place to be learning about conservatorship. So why? Guardianship happens when people can't take care of themselves in a matter that society believes is appropriate. So our individuals aren't necessarily going to care for themselves in the same way that society believes is appropriate. They need support. So what if? Remember that people put under guardianships because of perception that people with disabilities and older adults cannot take care of themselves in a manner that society believes is appropriate. What if your inability to take care of yourself is what's keeping you from working? So independent living skills are things like self-care, organization, communication, interpersonal skills. These are all skills that would enable you or prevent you from working. So learning to take care through special education. Students who have self-determination skills are more likely to successfully make the transition to adulthood, including improved education, employment, and independent living outcomes. Promoting self-determination is a best practice in special education. And later on here, I will review the new Department of Education transition guide that really emphasizes self-determination and self-advocacy. So in DC public schools, supported decision-making is built into special education. They have a program there that recognizes supported decision-making in special education, and they start as early as preschool. And like I said, there are decisions that every individual can make at any age. And so I think often when we're thinking about supported decision-making, we're thinking of more complex issues, but every individual starts somewhere in making choices, and teaching them to make their own choice at a very young age builds over time, and it becomes second nature. So in DC and in any self-determined goal, your goals would start with an I statement. So the student is involved and has accountability. And afterwards, if you would like me to provide you with resources and examples of various goals that can be written that are I statements, I would be really happy to do that. That could be related to writing. It could be related to behavior. It could be related to anything really that is something that the student is contributing to the content of, and also knowing what the goal is and owning it by having the goal stated as an I statement. And there are some websites here that can give you an outline and a framework of what could be done in other places. They have a question and answer sheet in the DC school system here that's available. They have a supported decision-making agreement that is filled out. And if you want more information about IDEA, you can go to the Center for Resources and Parent Information website here as well. So in special education, after a person turns 16, there is transition planning and transition services. And transition services include instruction-related services, community experiences, and the development of post-school adult living objectives, and when appropriate, acquisition of daily living skills. So that starts beginning not later than the year the student turns 16, and at least until the student is 21. So this is the transition guide that just came out in January 2017 from the Department of Education. It's a transition guide to post-secondary education and employment for students and youth with disabilities. So there is a section, if you go to page 35 through 40, about supporting student-made decisions, preparation for adult life. And it basically outlines 5 different areas. The first is setting high expectations. And of course, if you go to this link, you can have more information on each of these pieces. But they explicitly talk about high expectations and using person-centered planning, supporting the student's social and emotional learning, and informed choice. In addition, they talk about providing the student and youth with support to make their own decisions. They define characteristics of self-determination. So those are speaking for yourself, self-advocacy, solving problems, setting goals, making decisions, possessing self-awareness, and exhibiting independence. And so I've heard this asked before when people are talking about goals for supported decision-making. Often if you say supported decision-making to an IEP team, they're really not familiar with the term, which of course we want to familiarize them with that. But the more familiar areas of need that they are used to are self-determination and self-advocacy. So that's often what the goal will go under in terms of the area of need. Schools help students develop self-determination skills. So they basically spelled out that this is their job and that self-determination activities are defined as well, explicitly. So I really encourage you to go there. There was a lot of information that I couldn't include here, but I'm going over this very lightly, but this is a very big deal, exciting information for advocates, because previously this information was not outlined and explicit for people wanting to practice supported decision making, and for teachers and people on IEP teams who are just not familiar with supported decision making and self-determination quite as clearly. So transition activities, taking part in homeschool and community activities that relate to their interests, identifying and networking with people and agencies that can provide services and supports, and identifying short and long-term goals and providers of information, services, and training to help reach them. Transition services. If there are concerns that the student can't take care of himself or can't make decisions or may need a guardianship, transition services are a coordinated set of activities that should provide instruction, related services, development of post-school adult living objectives, and when appropriate, acquisition of daily living skills. This could necessarily include decision-making skills like supported decision-making. Transition services are so important, and often they are available at age 16, but often the schools and school districts or LEAs haven't put these services into place at age 16 or to the extent that they really should be. And it should be very individualized with transition and vocational assessments. And so supported decision making can be included in this acquisition of daily living skills. So transition agencies. Vocational rehabilitation assists with supports and services designed to help people with disabilities gain and maintain employment. Disability Rights University Center for Excellence, for example, the Mind Institute, is at UCEDD and Developmental Disabilities Council, state or local agencies providing services to people with developmental disabilities. Other transition agencies are independent living centers. Education, advocacy training, plans for self-sufficiency, counseling, service coordination, and other services designed to help people with disabilities live as independently as possible. And the Social Security Administration provides information, supports, and services to help people with disabilities become employed or maintain employment. So, supported decision-making and vocational rehabilitation. So the VR program provides services and supports to people with disabilities, to help people with disabilities prepare for, secure, retain, advance in, or regain employment. So prepare for, that means they are eventually employable. They don't need to be employable now. They need to be eventually employable. So if you need something to prepare you for work, get a job or keep a job, you can get it through the VR program, including decision-making and self-determination skills. Eligibility for VR. If you are eligible for VR, you are eligible for VR. If you have a disability, you want to work, then VR services will help you work. If you receive SSI, you're presumed eligible. IPE, the Individualized Plan for Employment. This lays out your employment goal, the job you want to get, and the supports and services you need to get there. And this is the very important regulation that you will see over and over here, which is 34 CFR 361.46. Very important. Very important. And here's why. If it's work-related, VR covers it. I'm sure if you've dealt with vocational rehabilitation, this may not be your experience. But as you can see here in 34 CFR 361.48, all of these services can be included. Some services that are available for the things that keep people with disabilities from working are assessments, counseling, job search and retention services, education, assistive technology, medical and mental health care, on-the-job training, job coaches, transportation, services to family members. People have gotten temporary rent, clothing, therapy services, even dental work, and other goods and services determined necessary for the individual with a disability to achieve an employment outcome. So basically, anything else that might be determined necessary for an employment outcome. And how I like to remember this is A through S plus T. It's almost everything in the alphabet if it's applicable to the person applying and it's eligible. The big one, vocational and other training services, including the provision of personal and vocational adjustment services, books, tools, and other training materials. And how is that an employment-based skill? Would you hire or retain someone who has difficulty following directions or staying on task, communicating with you or your customers, or getting along with coworkers? So this is often a question that people may be asked. How is that an employment-based skill? And these are very, very common skills that are difficult for individuals with disabilities, and even for people who are able to communicate when they get in social situations. It can be very difficult, and obviously, depending on the individual and the setting, they may need help with these skills. Life skills limitations. If your life skills limitations are related to your disability and make it harder for you to prepare for, get, or keep work, VR must provide services and supports to help them overcome them. So we want to be diligent in reminding them of 34 CFR 361.48, which I will not soon forget, and I hope you do not either. But there is a problem. There is a lack of coordination. The fragmented system of services within high schools and adult services are contributing to the failure to prepare people for the future. What does that have to do with supported decision making? What if the same skills you need to prepare for or get a job are the same ones you need to avoid guardianship? And I just want to go back to this slide that I was mentioning, the fragmented system of services. There are different systems and agencies operating basically as small islands. And there's often very little collaboration and communication between these systems, which is really essential to identifying what services the individual is getting on the whole. So a solution to that could be what is called a culture of coordinated support. So this is a state and system-wide agencies and organizations providing appropriate supports and services and collaborating with others to coordinate, complement, and supplement those services and supports. And this is being piloted in Vermont by Jessalyn Guston and Jonathan Martinez and the people there in Vermont. And basically, there is a coordination of all these agencies coming together. There is an idea that there could be something called a CCS that is attached to each of the different plans. And honestly, in this particular pilot, I'm not sure exactly what it looks like. It's being implemented as we speak, but it's basically the coordination of all these agencies together for the benefit of the individual. And so those agencies would include education agencies and student-led IEPs with transition plans, and employment and vocational rehabilitation agencies practicing informed choice, medical care, supports and services, that includes person-centered planning. So VR self-determination is built in. VR agencies must ensure that the person can exercise informed choice, informing each applicant and eligible individual through appropriate modes of communication about the availability of and opportunities to exercise informed choice, including the availability of support services for individuals with cognitive or other disabilities who require assistance, and exercising informed choice throughout the vocational rehabilitation process. Coordination is built in. The Workforce Innovation and Opportunity Act requires VR to put significant emphasis on the provision of services to youth with disabilities. And the federal law requires VR to become involved in special education services as early as possible. And I realize that that is not the case for many people. Coordination in transition. Remember, transition services are a coordinated set of activities. You have 5 years to coordinate services, to coordinate community experiences, to coordinate the development of post-school adult living objectives, to coordinate the acquisition of daily living skills, and to prepare for further employment, education, and independent living. So where does supported decision-making language belong? Now that we have established what supported decision-making is, why is it beneficial, and how self-determination supports and services are the key building blocks for supported decision-making skills? How do we begin now that we've established this? Where should supported decision-making language be incorporated? So this is a very common experience for individuals, families, and supporters that say, yes, I think supported decision-making is a great thing. It's going to enable this individual's rights, and I really want to help. And what do we do now? So supported decision-making language can be incorporated in two different ways. First, I want to say, and I should have said at the beginning of this webinar, that I am a non-attorney. I do not practice law. However, I did consult a leading attorney in this field, Jonathan Martinez, regarding the following guidelines. And so basically, there are attorneys who generally suggest one of two options. And what is very common are supported decision-making agreements, or what we're calling supported decision-making fold-ins. Basically, just supported decision-making language that is folded into documents that are already legally binding agreements according to current laws and regulations. And so that is a name I gave it, for lack of a better term, folding in the supported decision-making language. Option 1, supported decision-making agreements. So this is very common, and they're very thoughtfully written agreements that are recommended by multiple agencies and guided by the advice of attorneys. They are very valuable sample supported decision-making agreements that are available from the ACLU, ASAN, Texas, and Nanotech, for example. And I say here, see supported decision resource list, which I will make available to the Dale Law Firm after this webinar. And it's actually a really valuable resource list that I don't have included in these slides, so I will make sure I get it to them. And there you can access supported decision-making agreements and powers of attorney, what have you. So sample supported decision-making agreements are templates. They are altered according to the unique individual's needs. And so, pardon me, to go back one slide here. They are not a one-size-fits-all agreement. And if someone offers you a one-size-fits-all agreement, you should run. That is, if you're familiar with an IEP and someone handed you an IEP and said, this will be the perfect IEP for your child, that can't be, because the individual education plan is individual, and the individualized program plan is individual. And the supported decision-making agreement is very uniquely tailored specifically to each child, each individual, and their abilities. What are they able to do now? What, where can we start from here for each individual person? And so these are written by attorneys in plain language, so that it's easy to understand for people who are disabled or the elderly. So they're very specifically written, and written in a language that may be defensible if challenged in a court. And to date, there has been no court case challenging a supported decision-making agreement. And again, I will make these links available. They're very useful. It really helps families navigate what areas may be appropriate for individuals. And I shared with Stephen and Ellen that this will actually be a series of 3 webinars. And so we're going over part of supported decision-making now. There will be another webinar on healthcare and financial decision-making, and an additional webinar which will be about supported decision-making teams and setting the wheels in motion, and really getting into the details of how do we implement this for this particular individual. How are we going to do it? What are we going to do? Who are we going to have on our support team? And what is important to this particular individual? What are they deciding? How are they expressing that? How can we communicate with them? So there's a lot that won't be included in this particular webinar that we will cover further in our additional series as well. So supported decision-making agreements and case law. Supported decision-making agreements are currently only legal in 2 states. Very recently, that has happened in Texas and in Delaware. So they have passed legislation that is clear in those states. And in DC public schools, they have educational supported decision-making agreements. And there is case law and regulations related to supported decision-making. In the case related to Piri, there was a reversed order placing Piri under guardianship because she had in place a circle of support to assist her in making rational decisions concerning her personal finances and to meet essential requirements of health and safety. In the case on Damaris, guardianship was terminated because she was able to engage in supported decision-making. The court held that proof that a person with an intellectual disability needs a guardian must exclude the person's ability to live safely in the community supported by family, friends, and mental health professionals. So again, if they are able to live safely with the support of family, friends, and mental health professionals, then the need for a guardian must be excluded. In the case of Jenny Hatch, I actually met Jenny Hatch. She is just a lovely speaker and young woman, and she is one of the 2 most recent cases in 2013. She is a young woman with Down syndrome who avoided guardianship and won her right to work and live in her community with supports and services she chose, including the people. She preferred to help her do that. So 2 people named Jim and Kelly are a caring couple that support her today. And the story of Jenny Hatch was that she was working in a thrift shop. She was helping customers, and I believe she was able to use the register, and she was living independently. And something occurred where she was placed into a group home. She was locked away from her friends. People were not allowed to visit her. She was no longer able to work where she loved working or live where she wanted to live. And after the case was heard, basically what initially happened is that she was under a temporary guardianship for 1 year with people that she chose, Jim and Kelly. And at the end of that 1 year, she was able to choose whether she wanted to remain under the guardianship, which she did not. And essentially, she lives the same. She lives independently, doing the things that she loves and contributing to society without a guardianship and with the supports and services that she needs to do that. Another very recent case is Ryan King. And there's a quote here: Ryan is a whole person. We want him to be whole. The decision process is part of being whole. If I try to force Ryan to do something, I am destroying his selfness and being whole. He is a whole person, and he is making decisions, and I encourage him. That was by Herbert King about Ryan's story. And essentially, Ryan's parents conserved him, thinking that they didn't really need to, but they did because they thought that's what they should do. And it was apparent to his parents that he didn't need to be conserved. And of course, he didn't want to be conserved. And so they went through a very long process in this case where the judge did determine, yes, he does not need to be conserved. And so this is what we're referring to undue guardianship. There are often people who are conserved because that is what people know to do, and they think that is the appropriate thing to do, and are often motivated by fear because they want to keep them safe. But there are ways to keep people safe and to try first prior to conserving someone. And when someone is conserved, they lose their rights. There are 7 different rights that are withheld. It can be withheld, sometimes just 4, but often all 7. And I just want to tell a little story about that. I've gone to workshops where I asked questions, and this was a person that worked in 4 different counties. And I said, okay, so if you're a nonverbal person and you're going into the court and someone is trying to conserve you, is there a requirement, and I'm speaking for the state of California and this particular attorney's experience, is there a requirement that this person be provided with an AAC device, an augmentative alternative communication device? Do they have the right to have their device? If that is not brought into the courtroom, the opinion of this particular attorney was that they would be assumed that they were cognitively impaired and they would likely be conserved. And it was said very matter-of-factly. And so conservatorships have a requirement that the conservator exercise maximum and teach them maximum independence, but often that is overlooked and skimmed through. And so I think supported decision-making really emphasizes the need for people to be independent. And as we said, the National Guardianship Association recommends that you try other alternatives prior to conserving someone. So it's just an important decision to consider. There's also this client-lawyer relationship rule 1.14 related to client with diminished capacity. So a lawyer is regarded to follow this rule. The client may wish to have family members or other persons participating in discussions with the lawyer when necessary to assist in the representation. The presence of such persons generally does not affect the applicability of the attorney-client evidentiary privilege. So they may have family members or other persons participate in discussions with attorneys. So option 2, supported decision-making fold-ins, as we're calling it, folding in supported decision-making language into existing binding contracts. So there are those attorneys who alternatively suggest that supported decision-making language be built into currently binding contracts according to California state law. And of course, there are many people diligently working to get this included in California's legislation. But these contracts are already established, and so this is what we're recommending. Some of the recommended contracts to be used as a vehicle within which to fold supported decision-making language include the Medicaid waiver plan. Medicaid waiver programs help provide services to people who would otherwise be in an institution, a nursing home, or hospital to receive long-term care in the community. And you may have heard the term institutional deeming, which is also the Medicaid waiver program. Under the Medicaid waiver program, there is the Home and Community-Based Services, HCBS, which is a waiver. Waivers are one of the many options available to states to allow the provision of long-term care services in home and community-based settings under the Medicaid program. So states can offer a variety of services under the HCBS waiver program. Supported decision-making fold-ins and binding contracts, these are the services that are available under HCBS waivers. They can include case management, community transition services, private duty nursing, family training, home health aides, life-sustaining utility reimbursement, habilitation services, and respite care. So these are some of the services that can be provided. So the HCBS CMS rule, the Centers for Medicare and Medicaid Services, defines the settings by the nature and quality of an individual's experience. If your service gets Medicaid funding, this rule means you should have access to the full benefits of community living and receive services in a way that is integrated with the whole community. And some of the binding contracts that exist under the HCBS waiver and the CMS rule would be person-centered planning agreements, in IPP, individualized program plans, individualized plans for employment. And so I'll give you some examples of how that could be written in and attached and included in those plans. Alternatively, a power of attorney, money, banking, and healthcare are often included in this, and the people under which the power of attorney covers are presumed to be competent when they do it. So it says, I'm giving someone authority to make decisions. It also spells out how those decisions will be made. So this is something that some people may, professionals, I might say, would honor and not question a power of attorney. And so supported decision-making language can be built into all of these binding contracts that exist that people are often using. The HIPAA agreement for medical care, you can simply handwrite on the agreement, I would like this person to help me make my decisions. And in the individual education plan, the IEP as well, it can be written into the IEP that I would like this person to be my support person to help me make educational decisions. That could be a parent. That could be a parent and another supporter. Someone who is on the supported decision-making team. There is an SSI payee application that is not in plain language that makes the payee makes decisions, and is recommended that you can handwrite in the payee application language related to supported decision-making. And before I end this, I go to questions. I would like to go over some language that would go into that contract. So basically, you can say, I'm asking Susie to be my supporter and help me make decisions. There's additional language basically stipulating that they will defer to my preferences and my decision and help me in this particular area. So in the supported decision-making team setting the wheels in motion paper that I recently wrote with Jonathan Martinez, we talk about some of those areas that I thought about for my daughter or for any individual. That could be healthcare, it could be medical care, it could be education, and then very specifically for each person, that could be areas of behavior, it could be communication. So in my particular case for my daughter, we have a speech therapist as a support team member, and we have an educational psychologist as a support team member. And these are people that Kylie worked with in the past and who she knows and who she was very excited when I said, these people are going to help you make decisions. And I'm trying not to skip ahead because there's a lot that I can't cover in this webinar that we're going to be covering in an additional webinar, obviously the healthcare and financial decision making, but also more specifics about how they can be learning to make decisions and how each person does that learning. So if somebody uses visuals, they may have pictures. There is an ASHA communication Bill of Rights that's written in visuals. Individuals can do dream boards and vision boards where they express their dreams and preferences for the future. And then there's ways that supported decision making can be practiced on a daily basis. For instance, in a social story about what decision making is for that particular individual. And so I want to go back and focus on a particular individual that you may be thinking of. And for that individual, what choices are they able to make now? What decisions are they already making? What are their abilities? And that is the place that you work from. And decision-making skills build over time. And so, for instance, if there's an area that a particular individual is not completely proficient at and needs to learn over time, that doesn't mean that we completely exclude them from that area. For instance, finance. My daughter is not able to count change, but she is able to use an ATM card and pay in that way. And what else can she learn related to finances so that there isn't this roadblock of, oh, that person cannot make that decision, so we're going to make all those decisions for them. Even if that person needs support in every area, we want to take a look at what are their abilities and what could their part be in that area right now. And that will build and change through time. So the important thing is that you don't give up, and that supported decision-making, just like everything with individuals with disabilities, can be challenging. And we're starting this journey, setting the wheels in motion, and I'm really excited to continue additional webinar series so we can show you how to keep that going. And so I'd like to turn that back over to Stephen Dale, and it looks like we ended a little bit early, and I am open to questions that people may have. And also, I want to mention again that I am a non-attorney, so I will answer your questions, and if there's something that I feel Stephen can assist in responding to as an attorney, I will invite him as well.
Great. Now, hang on, Ellen, you're okay.
Yeah, my buzz. Okay, so there is one question for a parent with an adult with developmental and intellectual disabilities. What is the basic difference between a guardian and power of attorney?
You're breaking up just a little bit. What is the difference between?
Okay, for a.
Why don't you let me? Okay,
yeah.
Go ahead, Ellen.
Go ahead. You go ahead, Steve, with that. You can read it.
Yeah, maybe my sound's better. So for a parent with an adult with a developmental or intellectual disability, what is the basic difference between a guardianship or conservatorship and a power of attorney? And maybe you can contrast that with how would that work with supported decision making?
And in a power of attorney, they're presumed to be competent when they initiate the power of attorney. So you're saying, I'm giving some authority to make decisions, and it spells out how those decisions will be made. And it can include supported decision-making language. In a conservatorship, there are 7 different rights that are very specifically taken over by the person who's the guardian or conservator in the state of California. So that could be the right to vote. That could be where you live, who you live with, how you live, whether you get married. And so a conservatorship is very specific in the rights that it's taking away. And Stephen, would you like to explain that more explicitly for the audience?
Well, I mean, one of the things with the guardianship or conservatorship, and we have, as I was mentioning before we started this. I'm sorry, I have a little bit of a cough here. We're going to have to start adjusting our presentations, but we have a presentation that we do on conservatorships, but what we start off with is trying to find the least restrictive alternative and looking at whether a power of attorney, a advanced healthcare directive, and now we're going to need to add supported decision making is available. The difference is that a conservatorship is something that actually limits or takes away certain civil rights, and so that's why it's a judicial process, and that's also one of the reasons why one shouldn't do that lightly. But Suzanne, let me take this back to you a bit, and maybe here's something that I don't know. Every one of us should have a power of attorney or a healthcare directive in the event that we're unable to make any decisions whatsoever. So, for instance, I have a power of attorney, and if I were to have a stroke or something along the line that where I really couldn't advocate for myself, that becomes essential. So, going back to supported decision making, let's say we have somebody who sets up a supported decision making, and that's all working just fine. And just because you have one disability doesn't mean that something else could happen. So let's say they have a debilitating event that comes up. Does the supported decision-making do the function the same as the power of attorney? In a case like that, should you have a power of attorney with the supported decision-making? How do we address that kind of thing?
Well, language can be put into the power of attorney that says, I would like Joe to assist in my educational decisions or my medical decisions, and until the point that I become incapacitated, I will make my decisions with the support of Joe Fox. In the event that I become incapacitated, I choose Joe Fox or Sue Bank to assist to make my decisions. So that can be built into it. I don't know if that answered your question.
Well, so the question would be, I mean, once again, just thinking of real life people, we've shared this often. I have a niece named Erica who definitely can make decisions, and this is where supported decision making would probably be an excellent tool for her because she has an impairment, but as long as you get her the information and you have a good facilitator, she certainly can make her own decisions, and she should. Now, the thing would be, like, if we were to get a supported decision-making, the documents in order and get that all up and functioning, I guess the question is, should we have a power of attorney, a springing power of attorney, that would function also if she were to completely lose capacity because of some medical event or something along that line. And does it take legislation or, and if you're not sure, that's something that maybe we need to explore.
Well, I think that is part of what we say in terms of on an individual case by case and where the person is and where they are in the continuum of options. So like we said before, there's never a time that we wouldn't say there is never a need for a conservatorship, and there's never a time that we would say there's never a need for a power of attorney. And on a related note, I would also never say that somebody who conserved their child is wrong, because that is often a decision that people have made with the information that they had. And so we always encourage people to try supported decision making first prior to conserving an individual. And if your child is already conserved, you can practice supported decision making within the conservatorship. Now, again, the rights are already taken away at that point. But I do just want to be clear that what we're saying is try everything first. What have you tried first? What choices does the individual have to have independence in their lives? And
just trying to get my arms around this, because this is new thinking, and I was sharing with you, Suzanne, that my first impression of this was not sure how this would work, but we're seeing it work, and as I said, if it works in Texas, it's got to work here. So, but one of the things I think that one might be able to do, because I know many of the conservatorships we're involved in, you can always go back and give rights back to the conservatee. So I would assume that, for instance, if you had a limited conservatorship where you had gotten all 7 powers, and you might decide that, maybe it's best to hold on to the right to get records and make medical decisions, just as an example. But then it's all the other rights about choosing where you live and education and all that. You can always amend a conservatorship to give more powers back to the conservatee. It would seem like that might be a situation where you could work hand in hand with a conservatorship and a supported decision making. Once again, this is. Yeah, so it seems like there's room for a lot of creativity here, and all that.
Well, I guess the main thing that I would point out that can be done is a temporary conservatorship, like in the case of Jenny Hatch. She had a temporary or guardianship where she is. After the end of the case, she had a temporary guardianship, and from there she chose not to. And there are parents that have temporarily had a limited guardianship over an individual. But as in the case of Ryan King, once a person is conserved, it is not easy to get rid of the conservatorship or the guardianship. And in most cases, judges are really unfamiliar with supported decision making. And even in this case with Ryan King, which is very often the case, if the parents feel that or whoever the conservator is, feels that this person is independent, they're living on their own, they have a job, they can live and work in the community, and he doesn't need a conservatorship anymore. Everybody we know agrees with that. Judges are very hesitant to take away conservatorships or guardianships, and they're very unfamiliar with supported decision making. So that is one of the reasons that we really encourage people to hesitate and try everything else first.
Right, I certainly agree with that. Let's go back to Bonnie had a follow-up with the thing with the power of attorney. So she's saying she thinks she got it, which a power of attorney allows decision-making contractually in areas that specific decisions that can be made. The conservatorship in California is kind of dictated. That's kind of one way of looking at it. A conservatorship, really, honestly, is limiting your civil rights. I mean, that's exactly what it is. And it's a judicial process. In fact, the whole conservatorship process is focused on due process. Here, I think a lot of folks might argue that the due process isn't done very well, but that's what the whole process is about. So it's really limiting one's civil rights. A power of attorney, there's 2 types of power of attorneys. There's what are called durable power of attorneys that go into effect immediately, or springing, like, for instance, what I was describing for my niece. She definitely needs help with decision making, but to say she's incompetent or unable to make decisions, I think, would be inaccurate. So you might have something where it springs if an event happens. Supported decision making, I think, is along the same line, but it really goes into effect immediately, and I would assume continues as long as the person we're dealing with doesn't completely lose their capacity. Is that a good summary, Suzanne? Or
Yes, and supported decision-making agreements will likely change over time. And in the webinar where we talk about setting the wheels in motion, there are particular intake forms and ways of discovering who, what, and how the individual wants what they want in their life. Go ahead.
Yeah. Well, and I was going to say the other thing that your comment, and you know, it's interesting since I'm able to go from state to state in my bizarre little life here and see, for instance, what's going on in Texas. A year ago, when this was first introduced, there was a lot of doubt by the courts about what this was. Is it viable and that kind of thing? What we're seeing in the Texas courts now is they're starting to ask the right questions. It's like, well, before I take away this person's civil rights, did we consider supported decision making? And I think that's the direction that we're looking at going. And you know, my feeling is, just like you said, there's no right IEP, blanket IEP for everybody. There's no single answer for the disability community. This is just giving us more options, and you know, our movement in as far as community living is really, whenever possible, to give a person with a disability as much control over the life as possible. And hey, we all learn from mistakes. So unfortunately, we've kind of used to, like, if Junior makes a single mistake, we're never going to let him do that again. Well, where would we be if that's how we were treated, right? I make lots of mistakes here, and hopefully we learn from it. So
I think that's a very good point that you make that I actually didn't say, is that all of the rest of us get to make mistakes every day. And we really don't give people with disabilities the opportunity to do that. And if we already know that they may need support in a certain area and they have the support that they need, they can have the opportunity to learn from their mistakes. And I wanted to mention, because I'm really disappointed that I don't have the resource list available to you on these slides. I'm looking right at it. And what's really impactful and help people understand supported decision making are a lot of the sample videos that are available on the National Resource Center for Supported Decision Making website. So a lot of the resources I'm looking at are available on this website here, www.supporteddecisionmaking.org. And so there are presentations about supported decision making, but there are also stories of healthcare decision making, and also supported decision making in Delaware. And I believe there's also one from Australia in here that was really powerful. Then they have the ACLU brainstorming guide for supported decision making, the ACLU model supported decision making agreements, the DC schools information, and also the practical tool for lawyers, which is a tool for attorneys to use to assess the need for conservatorship, and it really goes over each step that they should review for supported decision making. So I will definitely make sure that I have this information available to you afterwards.
Okay, and then one last question, and as is the tradition here, I have to go soon because Mrs. Dale says it's time for dinner. And not only that, Suzanne's computer desperately wants to update her Dell computer.
I'm sorry.
It's really impatient. But one of the questions here, and this is something that I was curious about, is for an SSI payee. Here, Denise says, I don't understand the payee makes the decision part. Is that, if that is, it's the SSI recipient their own payee? So yeah, that would be curious. How would that work with SSI? Is that something practical we can do now, or is that a goal, or what?
That is something that has actually been discussed and published. Basically, their consideration of supported decision making, and it's something that they're talking about that they want to put into legislation. And so there's actually a link I can give to you that I didn't get included in these slides, but there is not a supported decision making form or agreement, but you could attach a supported decision-making agreement, and you can handwrite that in, that basically I want this person to help me. The best way I could describe it financially, and we will be going over it, is how much time do we have? Just a few minutes.
We have until my wife yanks me.
Basically, I heard a story, and this is related and unrelated. I heard a story about a young man who, through vocational rehabilitation and services, learned to work and earn money and put his money into a checking account, and he earned all this money, at, $900 in his checking account. And then the person who was appointed to help him as a guardian said, well, I don't know what to do. He's got this money and I have no control. And so basically, this person was instructed by an attorney who does conservatorships, showed her how to take away the money, how to take away those skills, how to take away all that work that person learned. Like, we should be so proud that this individual has learned to work and earn money, and they've got an account. That's great. And so that would be an example of taking away someone's rights. And talk about learned helplessness. I've learned all these skills and you're going to take away because you don't have control. And so that's where someone could have a supporter to help them make financial decisions. And I didn't have an exact answer for your question, but you're also welcome to email me afterwards and maybe I can answer it better for you.
Well, I'll tell you, I learned a lot, and, I have been kind of a student of this for some time. I wouldn't say I'm an expert here, but, once again, along with our movement of deinstitutionalization, which is more than just moving people out of institutions. It's people being part of the community, not just, this looks like a really good tool when it's appropriate, and it looks like something that needs to be discovered. And the exciting thing about it is, at a certain level, this is something in development. I know in California, and for those of you that attend the ARCA California Policy Conference, is going to be a major focus on supported decision making. And part of what we're looking at the ARC is, how to really incorporate that, in many aspects with folks with disabilities, to give the option to have folks be more in control of their life. Suzanne, I'm going to give you the last word, and then it's dinner time.
Thank you so much. I want to thank you, the Dale Law Firm, for inviting me to speak and help others in the audience. Thank you for taking the time to learn about supported decision making. And just remember that rights equals choice, and every single person has the right to make choices. And what have we tried first? Great.
So I know there was a question about handouts and that kind of thing, and Ellen will work with you to get the handouts to you. Assuming that the recording came out well, it will be posted within the next 48 hours. Stay tuned, because there will be 2 more segments of this here, and if you have any questions, feel free to forward them to Ellen at DaleLawFirm.com, and she will be glad. I bet you she'd be excited to pass those on to Suzanne. Suzanne, thank you very much, and honey, I'm coming upstairs, so okay.